Welcome to Tax Pundit. Today we are going to discuss a significant legal development in the case of Chander Pal versus Income Tax Officer. The assessee, Chander Pal, an agriculturist from Haryana, filed his return for assessment year 2017-18 declaring agricultural income of Rs 20,50,000. He later claimed this was an inadvertent error and the correct income should have been Rs 10,50,000. The assessing officer rejected this claim, estimating agricultural income at only Rs 5 lakh per year based solely on wheat crop data. The assessing officer treated the difference of Rs 15,50,000 as unexplained cash credit under Section 69A. The assessee provided key evidence, Khasra Girdavri showing cultivation of both wheat and paddy, Form J copies showing agricultural produce sales of Rs 9,62,217, an affidavit from return preparer Shri Kumar confirming the inadvertent error, and historical acceptance of higher agricultural incomes in subsequent years. The ITAT found the assessing officer's estimation fundamentally flawed. The assessing officer estimated agricultural income at Rs 5 lakh per year based only on wheat crop data, ignoring paddy cultivation shown in Khasra Girdavri. The tribunal held that total annual agricultural income must account for both Rabi and Kharif crops. The assessing officer's failure to consider paddy rendered the estimation incomplete and on the lower side. The ITAT noted that Form J showed aggregate agricultural produce sales of Rs 9,62,217, directly contradicting the assessing officer's lower estimate. The tribunal found merit in the assessee's submission that the assessing officer's determined agricultural income was too low. The documentary evidence supported the assessee's claim. The ITAT acknowledged the assessee's inadvertent error in declaring Rs 20,50,000 instead of Rs 10,50,000. While a revised return was the correct course, the tribunal held that the assessee cannot be left remedy-less for a bona fide mistake. Citing settled law, tax can be collected only as per law. If an assessee under a mistake offers excess income, authorities must ensure only legitimate tax dues are collected. The ITAT considered consistency with past assessments. Agricultural incomes of Rs 14,78,195 for assessment year 2018-19 and Rs 12,87,760 for assessment year 2019-20 were accepted by the department. While not binding, this consistency supported the assessee's claim that Rs 10,50,000 for assessment year 2017-18 was reasonable. The tribunal directed the assessing officer to accept agricultural income at Rs 10,50,000 and delete the Section 69A addition. The ITAT's decision reinforces key principles. Estimation of agricultural income must consider all crops. Bona fide mistakes can be rectified with credible evidence, and tax collection must be based on legitimate dues. The appeal was allowed, and the addition of Rs 15,50,000 under Section 69A was deleted. Question: what was the core issue in this case? Answer: the core issue was whether the ITAT would uphold the addition of Rs 15,50,000 under Section 69A of the Income Tax Act, 1961, made by the assessing officer for assessment year 2017-18, based on an alleged underestimation of agricultural income. Question: why did the ITAT delete the addition? Answer: the ITAT deleted the addition because the AO's estimation of agricultural income at Rs 5 lakh was based only on wheat crop, ignoring paddy cultivation. The assessee provided evidence showing sales of Rs 9,62,217, and the ITAT found the AO's estimate to be on the lower side. Additionally, the inadvertent over-declaration of income did not bar the assessee from claiming the correct income. Question: what is the significance of the ITAT's statement about tax can be collected only as per law? Answer: this statement underscores that tax authorities cannot collect tax on income that is not legitimately due, even if the assessee mistakenly declared a higher amount. The ITAT held that the assessee's inadvertent error does not justify an addition under Section 69A. Question: Did the ITAT consider the assessee's failure to file a revised return? Answer: Yes, the ITAT noted that the correct course of action was to file a revised return. However, it held that the assessee cannot be left remediless for a bona fide mistake, and the assessing officer must examine the evidence on merits. Question: What evidence did the assessee provide to support the claim of Rs 10,50,000 agricultural income? Answer: The assessee provided Khasra Girdavri showing paddy cultivation, Form J showing sales of Rs 9,62,217, an affidavit from the return preparer, and historical acceptance of higher agricultural incomes in subsequent years. Question: What is the practical takeaway for taxpayers from this judgment? Answer: Taxpayers should maintain proper records of agricultural activities, including Khasra Girdavri and Form J, to substantiate income claims. In case of inadvertent errors, they should provide credible evidence to the AO, and the ITAT may grant relief even without a revised return. Question: Can the department appeal this ITAT order? Answer: Yes, the department can appeal to the High Court if there is a substantial question of law. However, the ITAT's factual findings, such as the existence of paddy cultivation and sales evidence, are generally binding unless perverse. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at +91 93263 06668 for any assistance. Subscribe for more legal updates.